That's an interesting question, because what you're basically saying is anyone with a constitutional challenge of any kind, the ones I mentioned, selective prosecution, vagueness, whatever, has automatic standing to come to federal court. That's your theory.
The person has standing, but there are other obstacles that would keep many of those litigants.
But those obstacles will always involve the merits to some extent. They're going to involve that plus chill no matter what, correct?
No, the most important obstacle is irreparable injury. And chill is very important to establishing irreparable injury, which is a higher bar than Article 3 injury. And that's the main gatekeeper in our view.
How many states are the subpoenas self-executing, and how many of them aren't? Do you have any idea?
I don't have exact numbers, but my understanding is that the general practice is that subpoenas are not self-executing. That's true at the federal level and in the states as well.
In assessing the threat at the time when the complaint was filed, is it relevant whether it turns out later as a result of litigation in federal court or state court that the subpoena was not self-executing, or is the degree of threat to be assessed based on what one would know at that time regarding whether it was self-executing or not self-executing?
The normal rule is that standing is assessed at the time that the suit is brought, and that doctrines like mootness affect whether later developments change standing. And I understand there to be disputes between the parties about whether at the time the suit was brought it was clear that this subpoena was in fact non-self-executing. But we're willing to accept that for purposes of this case because the outcome, in our view, doesn't turn on that feature.
If I understand your position correctly from your brief, you think that the federal government is actually in a different position from the states with respect to the pre-enforcement theory, that because of the APA, the federal government would not be vulnerable to these kinds of actions. Is that correct?
In general, yes. There are some narrow statutes where Congress has authorized pre-enforcement motions to quash, and in those contexts, there would be Article 3 standing.
I guess it leads to the obvious question is whether you would have picked the theory that you picked if you were standing in the same shoes as the state is standing in. Because Mr. Iyer will tell me if I'm wrong, but I took from his brief that that the state was actually more concerned with the pre-enforcement theory than with the chill theory, that it seemed to it more disruptive of its ordinary processes of enforcement.
I appreciate that concern, and we agree that pre-enforcement challenges can, in some circumstances, be disruptive, but we just don't think Article 3 is the correct tool for addressing that concern. Instead, the main tool should be the irreparable injury requirement. There should be no basis for granting a preliminary injunction unless there is some irreparable harm that will be suffered before the state court ultimately orders enforcement. In the vast majority of subpoena cases, that won't be the case, but in First Amendment chill cases, that often can be shown.